this has been in the news for the past 4 days. Itong final ni Kaufman, Attorney Nicholas Kaufman, defense lawyer ni Duterte. And I suppose this goes back to a very basic or base issue of jurisdiction. Again, the jurisdiction is being challenged. But I suppose you also expected that, that any lawyer would, from the very start, challenge the jurisdiction to lay the base claim. First of all, let me ask you your opinion of his claim, his assertion actually, the court actually took cognizance of the case only 2 years after the Philippines withdrawal took effect.
Well, the answer there is the Burundi Pretrial Chamber 3 decision, that was 2017. And it states there that the withdrawal of a state party does not affect the jurisdiction of the ICC. So, and in fact, this was also invoked by the Pretrial Chamber 1 when it actually ordered the reopening of the investigation. I think that was sometime in January of 2023. And i-relate din natin to sa Article 29 of the Rome Statute, which provides that international crimes under the jurisdiction of the ICC are not subject to statute of limitations. In simplest terms, international crimes under the ICC are not subject to prescription. Prescriptable po sila. Kaya this will only be true if besides the withdrawal, yung walang effect itong withdrawal na to sa pag-exercise ng jurisdiction ng ICC.
Pero sir, if I remember right, itong decision ng Pretrial Chamber 1, medyo close yung vote. Ito ba yung vote na 2 versus 3 where nanalo lamang by 1 vote the decision to pursue the case?
Oh, actually you're referring, Ed, to the Appeals Chamber decision on July 2022. Oh, I'm referring to the Pretrial Chamber 1 decision to authorize reopening noong January 2023. But in any case, actually what the defense has been citing are the minority opinions nung dalawang justices ng Appeals Chamber. But we know na what's effective is actually the majority opinion, yung 3 against 2. Yun lang pong panghahawakan namin. At also, Ed, I want to add that from a very historical context, international criminal tribunals are actually hesitant to divest themselves of jurisdiction. That has been the historical record from Eichmann in the 1960s until the ICTY in Prosecutor versus Tadic, and even in the Special Tribunal for Lebanon. If there is a jurisdictional challenge, malamang po that will actually be denied by the International Tribunal. And we think that this will still hold on yung historical record na to.
Actually, I've heard that phrase floated around, yung malcaptus bene detentus, if I think...
Malcaptus bene detentus. So, that pertains to, yung challenge to the jurisdiction based on the alleged questions on the arrest. Pero hindi naman siya in-invoke dun sa jurisdictional challenge ng defense.
Pero I can imagine that that's going to be the next challenge if it does cross over to that portion. I also remember kasi for example, in one Senate hearing, former former Associate Justice Adolf Hascuna was saying na, at least as far as his opinion was concerned, walang problema yung arrest warrant ng ICC, that is all regular. The problematic area could possibly be dun sa the act of surrender, or the way that the former president was surrendered to the Interpol. I'm wondering lang what kind of weight that opinion issued by Justice Hascuna could have on the ICC, if at all.
Actually, Ed, because the ICC is an international tribunal, it's actually, ang kanyang basehan lang nito ay international law, specifically the Rome Statute. So, and in fact, it has been the doctrine under international criminal law na any questions on the arrest should not affect the exercise of jurisdiction. Yun nga ang very heart ng Malacaptus Benedictus. Kaya hindi po makaka-apekto. Kung ano man po naging opinion po, ano man po naging kukuko ng kung sino man po na nasa Pilipinas patungkol po sa naging arrest kay Mr. Duterte. So hindi po ito makaka-apekto sa jurisdiction ng ICC.
So, sir, moving forward, the defense has issued, or the defense has already made its filings. What's the next step here? Does the prosecution have to respond in kind, or is it left to the ICC pretrial chamber?
Oo, bibigyan ng, syempre, no, ng period yung prosecutor to respond. And I even want to add, even the victims should be given time to respond because this actually affects the interest of the victims, and all of the victims should be given the opportunity to file their observation, their views and comments on this jurisdictional challenge.
Pero sir, timetables. Do we have any of the timetables?
As of now, wala pang timetable, Ed, but let's see, kasi it should be done before the confirmation of charges on September.
Which is
20.
September.
It will be all parties should be given a reasonable time to give their views and comments.
So sir, kailangan matapos to before September, this particular issue?
Kailangan po siyang matapos September 23, and in fact, under the rules of procedure and evidence, pwede rin siyang isama dun sa confirmation of charges, yung issue ng jurisdictional challenge.
Okay. Maraming salamat for joining us this morning, Gilbert Andres, Attorney Gilbert Andres, the Director of the Center for International Law Philippines. Sir, always a pleasure to talk to you. Thank you po.
Maraming salamat, Ted. Mabuhay po tayong lahat.